Did you ever advise the Post Office to pursue a prosecution to act as a deterrent to other subpostmasters from committing crimes?
I don't think so. No. When I advised, no.
In my opinion, it is in the public interest to prosecute Mrs. Gourlay because of breach of trust and the large amount of loss. And then prosecution and conviction will act as a deterrent to others. Hold on. Mr. Singh's solicitor has just said, I'm sorry, I don't think this document was provided.
So we're jumping back into Jarnail Singh's testimony, and he's being asked about whether he ever advised prosecuting the subpostmaster to act as a deterrent effect. And at first he says, I'm not sure, but then quickly follows up with a no, all I considered was the evidence. When an email of some of his advice about a sub-postmistress in Scotland is shown to the inquiry, and it clearly says that actually it'll act as a deterrent effect in his conclusions, Jarnail Singh's solicitor, who we didn't hear anything from on his first day of testimony, quickly jumps into action saying this document hasn't been provided. So what's happening? Let's find out as we jump into the inquiry.
Good morning, sir. Can you see and hear me?
Yes, thank you. Yeah.
Thank you very much. Good morning, Mr. Singh.
Good morning. Good morning.
Can we pick up where we left off yesterday, which was examining issues in the general sense on the process and the procedure for prosecuting suspected offenders? Did you ever advise the Post Office to pursue a prosecution to act as a deterrent to other subpostmasters from committing crimes?
How do you mean? Sorry, can you flash it up?
Well, I guess what he means is, have you ever said things like they'll melt away like the midnight snow if we actually, prosecute somebody? Things like those kind of things. I mean, it seems like a fairly simple question to answer. Have you prosecuted people as a deterrent rather than on the merits of their own case?
That a little bit, so I can. From my recollection, no.
Putting it another way, was the aim of deterring other potential offenders a relevant consideration in deciding whether to prosecute a subpostmaster?
I mean, this shouldn't be a hard question. It should be no. It was based on the evidence available at the time that a crime had happened and that the person we're accusing had actually done that crime.
I don't think so. No. When I advised, no.
And why do you think no?
Because you're working on the merits and the evidence before you on that particular case. You're concentrating on what's before you. You're not sort of looking beyond anything beyond that.
Okay, can we look please at poll 00107869, and if we just look at the email at the bottom of the page, thanks. Thank you. And if we scroll up so you can see who it's from and to, it's from you to Mr. Scott, and it's essentially your advice on a charging decision, as I'm going to call it, for Christine Gourlay in Scotland. And you say, I've read the file and having reviewed the papers, in my opinion, there is both sufficient evidence to provide a realistic prospect of conviction of Mrs. Gourlay, and it's also in the public interest to prosecute her. Do you see that?
Yes.
And then over the following pages, there's an analysis of the allegations, the evidence, possible defences, and the like. And if we can turn to page 4, please, and look at the bottom, please. Thank you. And just to scroll down a little more. Thank you. Under conclusion, paragraph 28, you say, in my opinion, because of the above evidence and matters, there's sufficient evidence to provide a realistic prospect of conviction of Mrs. Gourlay. In my opinion, it is in the public interest to prosecute Mrs. Gourlay because of breach of trust and the large amount of loss. And then prosecution and conviction will act as a deterrent to others.
Well, there you go. He has said it. It's going to be a deterrent to others. So it might not be the only consideration he's making, but it's certainly one he's highlighting there that we can see.
And Mrs. Gourlay in her interview is implicitly attempting to blame innocent parties. So it's the part of the sentence there which says prosecution and conviction will act as a deterrent to others. That tends to suggest that in deciding whether to prosecute or not, you did take into account the possible deterrent effect of a prosecution and perhaps conviction upon others. Would you agree?
Oh, firstly, it's such a long time ago. I don't know the full details. I would have read the files in depth, considered it, maybe in general terms, but not the main ones are. The fact is, there's evidence. The public interest is the breach of trust. There's a large amount of loss.
I'm not asking you about those. I'm asking you about the bit of the reasoning which says prosecution and conviction will act as a deterrent to others.
But that, maybe just complete the sentence or something, but it wouldn't be...
It was just to complete the sentence. I mean, I think what he might be trying to say is it was a nice to have. In my opinion, the evidence was there, the public interest was there. Presumably the evidence showed that it was her and that they got the right person. But, if this acts as a deterrent to other people, then absolutely we'll have that slam dunked. But then if it is just a side effect and nice to have, there's probably no need to mention it in your conclusions.
To be honest, that's never actually gone through. It's not the process I would follow. I don't know why, in these circumstances where there was something in the in the investigation officer's report or in the interview, or something that John Scott, I think, specifically asked me to consider. But
there's a bit of deflection going on here again. This is an email from him, it's written by him, or at least he's not suggesting otherwise, and it's his advice on the prosecution as the only criminal lawyer. I mean, he can try to say that it's not the way he thinks as much as he likes, but clearly it was the way that he thought when he was writing this email.
In general terms,
he didn't.
That wasn't the aim. It's certainly, I accept the fact it's here, yes, but it's not the main. It's never been the main consideration in any of my advices or in my consideration. For some reason, it's there because it's peculiar to these details that's in this particular case. I don't know whether he's particularly asked or the investigation officer asked or he asked me to address it. But yes, it's there.
In the documents that we've got, the investigation report and the other communications from Mr. Scott, he doesn't ask you, please can you include in your advice whether or not prosecution and conviction will act as a deterrent to others, and please include one way or the other in your reasoning whether you take into account or leave out of account the possible deterrent effects. It's something that comes from you and not him.
Yes, but maybe then it's such a long time ago. I don't know, maybe on that particular day, but certainly generally I wouldn't have. The other advices you've probably seen, it's not there.
Was this a...
Can I just interrupt? I don't think this document has been provided to Singapore.
So the solicitor has said... Sorry, sir, you won't be able to hear because the... Hold on. Mr. Singh's solicitor has just said, I'm sorry, I don't think this document was provided before. I'll check whether that's so. And if Mr. Singh needs any time at all to read it, he should have it.
I agree.
Thank you.
Do you need time to read this document?
Is that the only... Have you got quite a bit of papers from you?
I'm sorry?
Have you got quite a bit of papers to go the background to it? So can I have as much as information you got?
I can certainly research that and come back to you later in the day or when you come back next year. If that would assist, I don't know at the moment whether this was a document that was provided or not. I can just check, however.
Interesting, so we didn't hear much from his solicitor, or we didn't hear anything from his solicitor on day one. Do you think they've had a bit of a powwow over the evening and tried to say, let's try and throw as many spanners into the works as we can today? I don't know. Maybe it just is the case that this document hasn't been provided. I guess we shall see.
Yeah. Yes, it was part of the batch of documents that was provided last week. It's tab E92. So you have had it before. I'll move on.
I mean, that would make sense. I mean, at the inquiry, they've been nothing but professional, and you wouldn't expect that to have slipped away from the retention, but it sounds like maybe Mr. Singh's own lawyer needs to be paying attention a bit more, because it sounds like she's had that document for over a week.